Brendan Dassey, Trial Transcripts, Day 4, continuing on page 97, cross-examination of Dr. Eisenberg. That is correct, sir. You were able to determine that from your testimony, I understand it, that those skull defects could not have occurred during the burning process? That is correct. Would have to have occurred prior to the burning process? Yes, sir. But would you agree there is no evidence, at least from what you have testified to so far, that indicates that the individual was alive at the time of the two gunshot wounds? I cannot make that determination. That's not within my field of expertise. So when you say this is the manner of death, it's more of an educated guesstimate versus an exact determination? Well, I am not a medical doctor, sir, but based on my experience and having examined other cases that show these characteristic signatures of gunshot wounds, it's my opinion that it certainly would have contributed to the cause of death. If the person were alive prior to the gunshots. Yes, sir. Correct? Okay. Were you present during the 4 burn barrels you testified to? Were you present during the sifting of those burn barrels? To my knowledge, I was not, although I would like to qualify that answer by saying that I did have occasion on 2 separate occasions to re-examine material that may have originated from any one of those 4 burn barrels. Okay, that's all. Thank you. Thank you, sir. The court. Any redirect, counsel? Attorney Fallon. No redirect. The court. You may step down. The witness. Thank you. The court. You're welcome. Attorney Fallon. I believe there's a trial stipulation. The court. There's an additional trial stipulation. Ladies and gentlemen of the jury, I remind you what I told you earlier this morning about stipulations. They are evidence. I'm going to read the following as a trial stipulation. Number 1, Dr. Jeffrey Jentzen is the Chief Medical Examiner for Milwaukee County, Wisconsin, and is a board-certified forensic pathologist. Dr. Jentzen agreed to be a medical consultant in this case and offered expert opinion as to the manner and cause of death of Teresa Halbach. Number 2, that if called to testify, Dr. Jentzen would state that after consultation with forensic anthropologist Dr. Leslie Eisenberg, he reviewed reports, photographs, x-rays, bone fragments, and other materials surrounding the Teresa Halbach death investigation. Dr. Jentzen would testify that in his expert opinion, to a reasonable degree of medical certainty, the manner of death of Teresa Halbach was homicide and the cause of death was gunshot wounds to the head. To the prosecution, is that your stipulation? Attorney Fallon, it is. The court. To the defense? Attorney Freeman, yes. The court. It will be marked as exhibit number 200, marked for identification. The clerk. 200. The court. Exhibit number 200. Do you have an additional witness? Attorney Fallon, I think we can start. We will not finish. The court. All right, please start. Attorney Fallon, state at this time would call Detective Anthony O'Neill. It may take us a moment to set up. The court. That's fine. Just come here, remain standing, and take the oath, please. Anthony O'Neill, called as a witness herein, having been first duly sworn, was examined and testified as follows. The clerk. Please be seated. Please state your name and spell your last name for the record. The witness. Anthony John O'Neill. O''N''E''I''L''. Direct examination by Attorney Fallon. While we're setting up here, I'll ask some preliminary questions. For whom are you employed, sir? The Marinette County Sheriff's Department. And how long have you been employed at the Marinette County Sheriff's Department? Approximately 18 years. And in what capacity are you currently employed? A detective. And how long have you been a detective, sir? Since 1998. And during your time as a detective, have you been asked to interview both witnesses and suspects in your capacity as a detective with the Sheriff's Department? Yes, I have. And during the course of your time at the Marinette County Sheriff's Department, have you participated in homicide investigations? Yes, I have. Approximately how many homicide investigations have you been involved in? I'd say about 8. All right. And in terms of general investigative experience, how many investigations? Any reference? It's the bulk of my job. Okay, fair enough. I'd like to direct your attention to a particular day, and that would be Sunday, November 6, 2005, shortly before noon. On that day, did you have occasion to assist the Calumet County Sheriff's Department and the Wisconsin Department of Justice investigation involving the missing person of Teresa Halbach? Yes, I did. And first of all, tell us how you became involved. On the previous day, our office was contacted by the Calumet County Sheriff's Department and asked to assist them in speaking to the Avery family. The family maintains a property in town of Stevenson in Marinette County. Our understanding was that the Avery family was at that property, and Teresa Halbach would have been at the Avery property in Manitowoc County previous to coming up there, and she was reported as a missing person. All right, and who, if anyone else, from your department was involved in assisting the Department of Justice and Calumet County Sheriff? primarily myself, Detective Todd Baldwin, Sergeant Michael Siegert, and some patrol officers as well. All right, and again, particularly with respect to the late morning, almost noon hour, what role were you asked to fulfill by the Department of Justice and Calumet County Sheriff? We had arrived at the Avery property a little earlier in the day and completed some of the interviews that we started the day before. We were also in preparation of or anticipating a search warrant for the 2 vehicles that were located at the Avery property. All right, now it might be of some help if you kind of direct that microphone a little bit closer to your mouth, or maybe tip it up a little, I guess. Okay, is that better? Yep, yeah, that's better. Maybe the end, just straighten the end out. There you go. That should do it. All right. What were you asked to do? We were asked to stand by the Avery property in anticipation of a search warrant being completed. All right. And what kind of what was the object of the search? The seizure of Stephen Avery's Pontiac Grand Am, I believe it was, and also the Avery Auto Salvage flatbed towing vehicle that was at that property in the town of Stevenson. All right. And who else, in addition to members of the Marinette Sheriff's Department, were present to assist in the execution of the warrant? Also with us was a Department of Justice Special Agent Kim Skorlinski. All right. Did there come a time where you executed the search warrant and seized the vehicle in question? Yes, the vehicle actually left the premises with 2 occupants, and we subsequently stopped the vehicle in anticipation of the search warrant and seized the vehicle. All right. And who were the occupants of the vehicle at the time of your seizure? The driver of the vehicle would have been Brian Dassey, and the passenger would have been Brendan Dassey. All right, and the passenger, Brendan Dassey, do you recognize him as being present in the courtroom today? Yes, I do. And would you briefly point out where he is seated for the benefit of court and jury? Mr. Dassey is seated to the left of me, wearing a white long-sleeve shirt, a pair of glasses, dark-colored pants, and I believe a pair of sneakers. All right. Attorney Fallon, the record reflects the witness has identified the accused. The court, so reflect. What happened when you stopped the vehicle with the 2 passengers, the defendant and his brother? When I approached the vehicle, I introduced myself to the driver and Mr. Dassey. Stated for them we had a search warrant for the vehicle and that we needed them to exit the vehicle and that we would provide them a ride back to the Avery property. Now, at that particular point, did you decide to interview either one of the occupants of the vehicle? Yes. What did you do? I asked Mr. Dassey if he'd be willing to talk to me in my vehicle, and he told me that he was not under arrest, free to leave at any time. And can we identify which? The court. Right. Attorney Fallon. We'll get there. The court. Well, have him identify which Mr. Dassey. Attorney Fallon. I was just about to do that. The court. Okay. By Attorney Fallon. Since there are 2 Dasseys here, if you would refer to them both by their first and last name, that would help, okay? Yes. Did you interview either one or both of them? I interviewed Brendan Dassey. All right. And who, if anyone else, participated in the interview of Brendan Dassey? Detective Todd Baldwin. All right. And while you were interviewing Brendan Dassey, what was going on with Brian Dassey, if you know? Brian Dassey was being interviewed by Agent Kim Skorlinski and his partner. Where did the interview of the defendant, Brendan Dassey, take place? In my unmarked police car. All right. Now, during the course of, well, let's ask it this way. Approximately how long or how much time did you and or Detective Baldwin spend interviewing Brendan Dassey? I believe it was just a little bit over an hour. And during the course of the interview, was there a free give and take between the participants in the conversation? Yes, there was. All right. And at any point during the course of your conversation, your interview of the defendant, Brendan Dassey, did he ask you to leave? No. All right. Did he ask or make any other requests of you during the course of the interview that you recall? No, he did not. All right. During the course of the interview, did he refuse or decline to answer any of your questions? No, he did not. All right. Now, this interview, was it recorded in any way? Yes, it was. All right. Tell us about what recording device and how that came to pass. In my car, I have a digital audio recorder. It's just a small pocket one, and during the interview, it was in the record position, and once it was recorded, I archived it to our department computer and subsequently sent to the district attorney a copy of that audio file, actually 2 audio files. All right, now let me ask you this. Where in the vehicle was your recorder? It was in my visor. I have a visor caddy, so it's placed up there. All right, and who sat in the front seat of the car? I sat in the driver's seat, Detective Baldwin in the passenger seat. All right, and where did Mr. Dassey sit? Brendan sat in the back seat, passenger side. All right. Now, during the course of this did Mr. Dassey audibly respond to all of your questions? For the majority, yes, but he's a very much nonverbal responder as well. All right, so what type of nonverbal responses or cues were you receiving from him during the course of the interview? Sometimes he'd go, mm-hmm, in that sense, not an affirmative yes or no, or and then those were the responses that were outside, yes or no, or any explanation. But then we also look at nonverbal type responses as well. All right, and did you receive, from time to time, nonverbal responses during the course of this? Very much so. All right, and thus the recording that we're about to play does not contain all of there's no way of capturing the nonverbal responses. That's correct. All right, during the course of this interview, did you promise Mr. Dassey anything in an effort to get him to talk to you? No, not at all. Very well. Attorney Fallon. Your Honor, at this time, I guess we would begin to play the interview, recognizing that it may go and will go longer than 12. So do you have an idea as to when you'd like us to, yeah, there is 2 parts to it, so we might be able to take a break at the end of part 1. The court, how long is part 1? Attorney Fallon, probably about a half hour. The court, okay, then let's do that. Attorney Fallon, all right. The court, start playing and we'll cut out after part 1. Attorney Fallon, okay, very well. The court, all right. Do you want this taken by the reporter? Attorney Kratz, no, we actually have a copy for the court, Judge. I don't have any objection to. Attorney Kratz, the counsel, the court, Kratz, reporter not taking it. Attorney Freeman, just one moment. The court, while they're talking, is there a transcript as well? Attorney Fallon, I believe we have this is a closed caption, so it will be a read-along or a follow-along. The court, I understand that, but is there a separate has someone transcribed this? Attorney Kratz, we can check, Judge. Attorney Edelstein, Your Honor, I don't believe it would be necessary for the reporter to take this portion down so long as it consists solely of the audio that this witness has described, and we're not stopping and starting for questions of the witness. The court, and is that, Mr. Fallon, is that what you intend to do to play this completely? Attorney Fallon, yes, we're going to play this one at least, I would say pretty much all the way through, and then we'll have some follow-up questions for Detective O'Neill and perhaps for Detective Baldwin as well, and tender them for cross. Counsel is providing me, we do have a typed transcript that we could utilize as an exhibit, or our preference was simply going to be mark the audio copy as the official record. And the court, all right, Attorney Fallon, use that as an exhibit. The court, any objection to doing that, counsel? Attorney Edelstein, none. The court, marking the audio copy. Attorney Freeman, that's fine. The court, or the CD. Attorney Freeman, right. The court, okay, that then would be Exhibit 201. The clerk, it will. Wherein CD is played, wherein CD is stopped. Attorney Edelstein, may we approach? Discussion off the record. The court, all right, proceed. Wherein playing of CD continues. The court, is that the first disc? Attorney Fallon, that's the first half, or we're about halfway through, so it probably would be a good time. The court, sure, we'll break for lunch. We'll be back here at 1:15. Ladies and gentlemen, I'll remind you, don't talk about this among yourselves or with anyone else. We'll see you at 1:15. Recess had at 11:59 a.m., reconvened at 1:10 p.m., jurors not present. The court, before we have the jury back here, it's my understanding, Mr. Edelstein, that you wish to put some matters on the record? Attorney Edelstein, yes, Your Honor. Thank you. Not long after the last witness, Detective O'Neill took the stand, and the government started playing an audio of an interview of November 6, 2005. We did have a bench conference, and for the record, I'm asking the court to memorialize that. We'd have an objection to the visual display of the closed captioning with the highlighting of the line purportedly being broadcast through the audio being highlighted in a very bright yellow. As the court, I'm sure, is aware, the courtroom is set up with these monitors. I think everybody could agree that the jury is pretty much split down the middle, some looking to the left, some looking to the right, in order to try to follow along. The only graphic on the screen is, in fact, I believe, a clock timer showing the duration of the playing of the recording, as well as the closed caption, if you will, but it does contain the highlighted yellow portion. It's specifically to the yellow portion that we object. I believe it places an undue emphasis on the printed word as opposed to the spoken word, which is really the place the jury should be focusing, not on somebody else's transcription of what they believe to be the conversation to be. And for that reason, we have objected and do continue to object to the yellow highlighting. We have no objection to the display of the rendition, particularly if the court were to give the instruction I believe the parties have agreed upon. The court. Before I ask for a response from you, Attorney Fallon, I think what Mr. Edelstein has said accurately summarizes his objection raised at a bench conference. To put it in a little context, the yellow highlighter that he is referring to moves down the printed text that appears on a screen, and it does so in a manner that follows in a rough way, in an approximate way, the spoken matter that comes over the audio portion of the tape. Now, Mr. Fallon? Attorney Fallon, yes, thank you, Judge. I understand counsel's concern, but I guess I have two practical responses. First and foremost, I don't believe, and this is of course a judgment call on the part of the court, but I don't believe that the highlighting necessarily overemphasizes the particular line which is being broadcast or spoken at that very moment. In fact, the whole idea for the captioning and the yellow line is to try as best as possible to sync together the audio words with the written word, and thus make it easier to follow, especially, I might add, in a case where one of the participants in the conversation is a very soft-spoken individual, and there is some distance between that individual and the recording device. So in that regard, I do not believe that it overemphasizes this, because it's a momentary thing, and as the yellow line or highlighter or cursor follows the conversation in that regard, so I don't think it's an overemphasis. Secondly, and equally important, if not more so, is the fact that there is an instruction that we've agreed upon. Counsel has written it up, counsel for the defense, and I would encourage the court to read the instruction to the jury at each and every point that we're going to play one of these audio recordings, whether they are closed captioned or not, because the instruction is, and I think all the attorneys are in agreement, that the law is that the jury must first rely and trust the spoken word rather than the written word if there's some incongruence, and I think that would take care of the matter. The court. Presumably what you have in your hand is the instruction? Attorney Freeman, yes. The court. Why don't you bring it up here? All right. And Mr. Edelstein, you've agreed to this instruction? Attorney Freeman, I actually drafted the instruction, Judge. The court. Presumably that means you agree? Attorney Freeman, yes, we do. The court. All right. All right. The court is going to find just as, for the record here, that the yellow highlighter I believe to be an assist to the trier of fact in this case, that some portions of the audio are seemingly disjunctive in that one of the participants is in the back seat of the car, two of them are in the front seat of the car. There isn't perfect timing in doing this. The yellow highlighter brings to the screen the attention of the listener exactly what is being said, and court finds that to be an assist to the jury, which is the trier of fact, without depreciating from either the value of the nuance of any of the nuances of any of the words that are being spoken. With that said, however, I will, at the apparently joint request of counsel, read to the jurors each time that we undertake either an audio or a audio-visual this particular instruction. All right, anything else before we bring the jury back in? Attorney Fallon, no. I would indicate that we'll be resuming with Detective O'Neill. I will ask him, probably a half dozen or so questions right now just to break things up, and then we'll play the balance of this interview, and there will be a few more questions, and then Mr. Edelstein will cross. The court. All right, Detective, why don't you come back up here? Let's get the jury back in. I'll instruct them, and then you may proceed.